Deputy Clare Daly.
Thanks, Count Corla. Minister, this question relates to the Adoption Information and Tracing Bill, which thankfully now you are on the verge of concluding. And I think in framing the question, I think it's fair to say that you have delivered this bill in a manner in which the adoption community broadly believe was a very consultative and participatory process. But the one area that's kind of left, that I suppose this is a last-ditch plea to make what is a good bill even better, is the issue of the one-year lead-in, and I'm really asking you to look at that provision.
Thank you, Minister.
Well, I want to thank Deputy Daly, and just to assure that efforts have been ongoing and indeed been ongoing for many years to provide a statutory entitlement to information to persons separated as a result of an adoption. In this regard, the Government approved the publication of the heads and general scheme of the Adoption Information Tracing Bill in July of this year. The bill is intended to facilitate access to adoption information and operates on the basis of a presumption in favour of disclosing information insofar as it is legally and constitutionally possible. The bill will, for the first time, provide a statutory basis for the provision of information related to both past and future adoptions. It will provide clarity around the information that can be provided and the circumstances in which it can be provided. I referred the bill to the Joint Oireachtas Committee for Health and Children for pre-legislative scrutiny. The committee published their report last week, and my officials are currently examining the recommendations of the report. I note that one of the key recommendations relates to the length of time being provided for the operation of information and awareness campaign. The awareness campaign will be a high-level campaign to publicise the provisions of the new legislation, outlining what information can be provided to adopted people and birth parents and the circumstances in which it can be provided. It is part of a suite of measures that the bill provides in order to ensure the balancing of parental privacy with an adopted person's right to information. I would point out that during the period when the campaign is underway, the information required to apply for a birth certificate will be provided to an adopted person where a birth parent consents or where a birth parent is deceased. In this regard, the campaign will not impact on the sharing of information and our contact between birth parents and adoptees where there is agreement by both parties. I am aware that there is a level of dissatisfaction around some of the requirements of the proposed scheme. However, as you will appreciate, for the bill to be legally sound, it must include safeguards to protect the constitutional rights of parents to privacy and adopted persons to their identity.
Thank you, Minister.
I believe that the safeguards proposed in this bill, the awareness campaign, the statutory declaration, the offer of support and guidance and the possibility of an appeal to court provide sufficient protection of birth parents' constitutional rights to privacy and balance the right to identity information with protection of privacy. Any amendment to the bill must be considered in this context.
Thank you, Minister. Deputy Clare Daly.
Yeah, I mean, look, I appreciate that the Minister was pulled in different directions, that he was constrained by legal and constitutional issues, although I do in general have a problem with Attorney General's advices about them not being published and about if there is a constitutional impediment, that impediment should be addressed if we are to put the rights of children and the right to an identity in this instance first, as we should be, and I think it's another argument for why the Constitution should be changed. But look, I acknowledge the good parts of the bill, and I acknowledge that most people in the adoption community believe that the Minister's handling of it has been very positive. But the one key issue that is big time outstanding is the age profile of the people involved. Half of the people adopted since 1922 have passed away. Their natural mothers are considerably older, at least 20 years older, and you know, really the points they're saying, a year's delay is going to mean hundreds of other potential reunifications are going to be lost by holding off for a year, and it is a plea to say reduce it to, I would say, between maybe 30 to 60 days and have a much more intensive information campaign, reallocate your resources that you were planning for the year, hone them in on that period so we can facilitate people achieving a connection that many of them have long sought.
Again, I mean, I'm very aware, as the Deputy does point out, that the age cohort of many people involved means that time is of the essence from their point of view. and I certainly don't want any undue or any unnecessary delay. And it's certainly one of the areas that we're examining very closely. We have to have regard to legal advices. I know this creates problems from your point of view, but the law is there for a good reason, in fairness. Look, I'm looking at this very actively, and I will be endeavouring to do everything I can to reduce the period, but at the same time make sure that it's sufficiently long that it doesn't create a problem for the bill and undermine the bill from a legal point of view, because we have to be very careful here, and I think we have been very careful about unforeseen consequence. And the last thing I want is, having got this bill to this point, to have it challenged in court and lose and put down. So
thank you.
People have waited a long time for this. I'm very aware of the sensitivities. I know the hurt that people feel, and I know that sometimes they think maybe that we've been a bit too legalistic in our approach, but we have to make sure that the bill succeeds and gives them what they want, which is a right to their identity, and that it also provides, and does provide, for a proactive approach in terms of once somebody goes on the register, we will actively go and find the contact.
Deputy Daly.
I mean, I accept the Minister's intentions and bona fides on this. I suppose, you know, when the constitutional issues were addressed around the bill and ensuring that the Supreme Court ruling in relation to the right to privacy of the natural mothers were looked at, the one-year lead-in was looked at in that context, along with the veto, I believe, but that the one-year lead-in wasn't specifically, I think, part of the Attorney-General's advice in relation to that aspect of it. So given that the Minister has said that he is considering it, and in the spirit which is very important to the adoption community of no one being left behind, then I think hopefully we will be able to reduce that time limit. As I say, I'd love it to be 30 or 60 days. If it can't be a year, if we got 6 months, 4 months, I think every month that we can cut that down brings people potentially together to a situation where they can have their right to identity in some instances before they pass away, which is hugely important.
Thank you, Minister. To conclude.
Yeah, I'll be very brief. I just would like to reiterate that this is something that I'm very actively looking at and regularly reviewing, and that I would like to see, I'll say it here on the floor of the Dáil, I would like to see it shortened to the shortest possible time, but still remain safe from a legal point of view. And I'm not implying that the Attorney-General in this particular instance has given advice of the duration of a year, but it is legal advice we have at the moment, and we will seek to get hardened advice that will allow us to shorten it as short as we can. Can I just take the opportunity, I'll ask Sean Corley, to thank all those in the adoption community, those adoptees and those birth mothers, and all who've taken the time to come and speak to us, all those who made contributions during the pre-legislative scrutiny at the Oireachtas Health and Children Committee, and thank them for their forbearance, and to reassure them that we do seek to address this issue to their satisfaction. Thank you.
That concludes.